country's top court has refused to put a stay on its recent order, and that's exactly what we are discussing and debating right here on the India Development Debate tonight. You're back with me, Supriya, Shrinate. Remember, the Supreme Court has rejected a review petition by the government which pleaded for an immediate stay considering the emergency-like situation in the country. The top court has said that there is no sufficient ground for a review of the order. The court will hear the petition after 10 days. The ruling comes within hours after Home Minister Rajnath Singh told Parliament that it was not the government's intention to dilute the SC-ST Act. The Dalit agitations have come as a fresh challenge to the Modi government, which is already grappling with a host of issues including high fuel prices and desertion from some of its key allies. The impact of the Supreme Court's firm stance and no dilution or no changes in dilution right now, its impact on the government and various stakeholders is what we're discussing on the India Development Debate tonight. I've got Udit Raj representing the BJP. He's an MP from the party. Mr. Charan Singh Sapra, spokesperson of the Congress. Mr. Sudhindra Bhadoria of the BSP is right here with us. Mr. Satvik Verma, lawyer and columnist, and Mr. Anand Ranganathan, consulting editor for Raj. So thanks each one of you for sparing time and being with us. And I think it's only fair that I begin this discussion with the ruling benches. Mr. Udit Raj, the BJP approached the Supreme Court, the government approached the Supreme Court wanting a stay that hasn't come. By diluting the law, that's exactly what it's being called, do you believe the Supreme Court has taken the teeth away from the SC-ST Atrocities Act? Is there fear that, and you know, the fear is that the protection that this act guaranteed to SC-STs has perhaps gone? Is that what the concern really is? Mr. Raj.
Yeah, our concern is this only because insofar as arrest is concerned under this act, what happened in case of employee, appointing authority has to give in writing, mentioning the reason that arrest is to be done. And in case of public, SSP has to give in writing and mentioning the reason. In both the cases, supposing both the authorities belong to the same caste, are enjoying the good repo, or they can be influenced or bribed, or political pressure can be built up, so brought up. So what happened is that here the introduction of the third party, and Supreme Court, why Supreme Court has not taken such a view on 376 and other laws are also misused. I am not denying that in some cases there are misuses. Misuse is there, but saying that it's a procedure let down, I disagree with this. It's a dilution of the act. And as far as filing FIR is concerned, direct FIR cannot be filed, whereas in normal acts, direct FIR can be filed, because in this case the condition has been put was that DSP level officer has to make the inquiry. If he is satisfied, then FIR can be lodged. I for the one feel that of course no innocent can be punished, no innocent be arrested, but there should be for that other laws are also which are misused grossly at large scale. So let us have a mechanism that of course minimum possible way is to misuse the law. So I disagree with this, and the Supreme Court judges, many of the judges are biased. I'll tell you, I'll set the example of the Jaipur High Court, where in case of Bhavari Devi, judge said, judge said that how can a upper caste rape a lady, a Dalit lady?
No, Mr. Raj, you've made your opening comments there. I don't want to get into the specifics of the Jaipur case because this is an important matter and we want to spend some time discussing this. I'm glad you've made the opening statements and you believe that this act should not be diluted.
I'm saying the mindset of judges, why scheduled caste and OBC are not judges? Why is that itself says? Listen, let me make one point more. Just Mr. 1 minute, half minute. Why SC, ST, OBC are not judges in High Court and Supreme Court, and what is the merit, what are the criteria that one fine morning Chief Justice picks up one advocate for the justice, and is there any committee to examine or scrutinize his judgments, or is there any committee to examine his character? And why? Is it not a casteism? Supreme Court is not a casteism.
Okay. Mr. Udit Raj, Mr. Udit Raj, you've made that comment. It's very well taken. That's a point of view, and that's a point that I plan to discuss in the debate tonight. But I will take it across to Satvik Verma before I go across to Mr. Bhadoria and Mr. Sapra and Mr. Ranganathan there. And Satvik Bhadoria, we all know that there has been discrimination against the SC/STs for years, centuries now, and which is why this act was brought in to do away with this discrimination. Will the kind of dilution that the Supreme Court is talking about not lead to more atrocities against the Dalits and the tribals? I'm really questioning the timing of withdrawing some of the provisions there. What's with the timing? And I will discuss whether other laws have not been diluted, why this, but what is with the timing? I mean, why does the Supreme Court think this is the right time to do so?
So, Supriya, before I answer that question, I'm going to restrict my responses primarily to the legal aspects and not the politics of this. But at the outset, I'd like to express my deep sense of anguish towards the many people who lost their lives in the aftermath of the judgment and the riots that broke out all over the country, and especially in Madhya Pradesh yesterday. But to answer your question, Supriya, and you've in that question posed 3 or 4 things, so I'll answer them sequentially. Number one, Supriya, the Supreme Court, or any court for that matter, does not time its decisions. Therefore, it would be unfair and grossly unfair to attribute anything vis-a-vis the timing of a judgment. This was a matter that was pending before the Supreme Court. The Supreme Court had appointed an amicus curiae to assist the court because it realized that this was a matter of great importance that necessitated additional assistance. Once the arguments are concluded and the amicus files what is the amicus brief or their submissions, the court within the appropriate time decides and delivers the verdict, and therefore there is nothing that can be read into the timing. It's a pure coincidence. If you're combining this with anything else, that's purely a matter of coincidence. Number 3, the act was brought about not for the discrimination as much as to prevent the atrocities. And the act noted that the Dalits and the members of the scheduled caste and scheduled tribe suffered certain conditions that were and can be termed as atrocities, and a special legislation was needed. The legislation, as you probably know, is a special legislation, and it very clearly says that this legislation shall trump and apply over any other law in the country. What the relevant portion that we are discussing today, which pertains to the judgment, Supriya, deals primarily with section 18 of the act, which had prevented an accused from obtaining anticipatory bail and therefore had only restricted section 438 of the CRPC, while giving that accused the right to obtain bail under 437, which deals with general bail. So to explain that in a form of example, if an allegation was made against Mr. X for having committed an atrocity against a member of the community, and Mr. X was prima facie found guilty, then the moment an FIR was lodged, he could be arrested. However, once the FIR had been lodged, he could get regular bail, because as we all know, the practice in this country is regular bail over jail, and that's what Article 21 provides.
Yes.
Now, what this court has done,
Satvik,
Satvik,
I understand. Satvik, I'm sorry, I'll have to intervene. We can't, Satvik, I'm sorry, I'll have to intervene. You've made opening remarks and I get the legal standpoint from where you are really talking. Satvik, just hold your thoughts there. I want to go across to Mr. Bhadoria. And Mr. Bhadoria, I do know that the entire opposition seems to be very united in this matter. You know, the Congress, the BSP and everybody else in the opposition seems to be very active and united on this. But is the government to be blamed because the changes are being brought about by the Supreme Court? Excuse me.
Well, let me say this at the outset, that the Dalits are the most marginalized section of Indian society. And I must also say, as Mr. Udit Raj has said this, and I would like to supplement this by saying that it is also not the opposition alone. It is the BJP MPs themselves. They had gone and met the Prime Minister in a delegation, and I am quite sure Udit Rajji was also present there in that delegation. And some of their MPs have also taken out a lot of rallies, one of them being notable Sadhvi Jyotiba Phule, a member of parliament from Bahraich. She has said that the whole constitution is being undermined. You see, over the last few years, the Dalits are being pushed against the wall. What happened in Una, what happened in Saharanpur, what happened with Rohit Vemula. So there are a whole spate of incidents that have taken place, which has created in the Dalits a fear that they have no space left in the system, and whatever rights they had got, for instance, this Dalit this act of atrocities was brought about in 1989 when Manavar Kashiram and Behan Mayawati ji put a pressure. The then VPC government made this a law. Baba Saheb Bhimrao Ambedkar was also accorded the Bharat Ratna at that time. Now we see that over these few years since the BJP has been in power, there has been a systematic act where they have tried to marginalize these and push them against the wall because of the incidents that I have narrated to you. Insofar as the misuse of law is concerned, as has been rightly pointed out, you see there is an Anti-Dowry Act. Many people complained about it, but there is no hue and cry over it in the country. There is a committee which was set up under the Chief Justice Verma, and there was at the time of Nirbhaya Kand, we all supported that there should be a strong law, but some provisions, but then you don't change the law, you don't dilute the law because some misuse has been made, and therefore it is our fear that by doing so they are trying to further push these very marginalized sections which Baba Saheb Bhimrao Ambedkar empowered through the constitution. They are being pushed against the wall so that they have no space left in this system.
Okay, Mr. Bhadoria, your opening comments are welcome, and you do make a distinction between what the BJP stands for and what some of the MPs belonging to the Dalit community in the BJP stand for, and I have a question on that. But before I go across to anybody, I think it's only fair that I ask Mr. Sapra, and the Congress has been at the forefront of these agitations as well, Mr. Sapra, and while we greatly lament the loss of lives and the violence that crept in, I have to ask you a question. What is the Supreme Court asking to be done? The Supreme Court says that bail can be granted in cases where there is a lack of prima facie evidence, and for the arrest of public servant, there should be a necessary approval from the public authority. Now, we do know that these are perhaps the few instances and these are perhaps the few issues over which there has been a misuse of these Atrocities Act. Is this then not fair that these perhaps stand corrected? Mr. Sapra.
See, first of all, I would like to say that whatever situation has come today, it is due to the gross negligence of the government, whether it is the issue in the court or whether this was the issue to handle the situation of Bharat Bandh. Now, you know, Bharat Bandh was announced 4 to 5 days earlier, but government did not take any precautionary measures. They never visualized, and probably the intelligence of the state governments and also the central government failed to assess that this kind of situation can happen. Moreover, in such a situation when people are protesting, there were certain miscreants, and those miscreants belonging to the ruling BJP or the Bharatiya Janata Party or Vishwa Hindu Parishad or Bajrang Dal, they entered into it. Now, if you see all the channels today, one person, Raja Chauhan, who shot at few people and 3 people were killed in Madhya Pradesh, he has been arrested. He is linked to Bharatiya Janata Party. So somewhere there was a modus operandi or a serious planning of Bharatiya Janata Party and RSS to take the advantage of this situation also. Whereas when you see the matter in the court, it was a gross negligence on the part of the government, because government did not take it seriously when the first notice was issued on 20th November 2017. The notice was issued to the central government as well as to the Maharashtra government. But government did not take it seriously and they took time ahead
Again in January 2018, the Additional Attorney General filed
Right,
a reply
right.
in which he mentioned few clauses which was to dilute the Atrocity Act. Now, when such
Right.
an important thing is there, the
Right.
parliament session is on, the government could have easily represented in the court
Right, right,
that we
Mr.
will take
Sapra.
this issue in the parliament because laws are to be amended and to be made in the parliament, not in the courts. So government was not serious in
Right.
this. It was a
Right.
gross negligence on the part of this government, whether it was in the court or whether it was on the field. So government is solely responsible,
Okay.
and Mr. Uday Raj,
Okay.
who's the BJP MP, he also agrees. You ask Savitribai Phule, she's a BJP MP, she will also agree that this is a gross negligence
Right.
of the Bharatiya Janata
Right.
Party government or the Modi government.
Okay, Mr. Sapra, I get your point there. I'm tempted to go to Anand Ranganathan for a more elaborate question on the issues which have been raised by the Supreme
take me
Court.
in
But
trap.
I will come across to Mr. Udit Raj. And Mr. Udit Raj, one second, Mr. Udit Raj, I have a pointed question for you. And that question is that has there been a disconnect between the party and the government on one hand and some of you representing the community on the other? I mean, what explains the fact that the government almost had to be cued by the opposition to go to the Supreme Court? The government wasn't willing ever to go. It happened on the 20th of of March when this verdict came. The government was in no rush. The Additional Solicitor General Maninder Singh was on board with dilution. He did not object to it. So, I mean, the political fallout perhaps prompted the government to go ahead. Is there a disconnect between the government party and some of you who represent the community then?
Certainly there is a lack of communication. I will not deny it, but you cannot blame the government intention and government. Next day, Thawarchand Gehlot ji made it very categorically that we are going for the review. And the judgment was delivered on 20th of March. And of course, it takes 2-3 days to read it and analyze and see the pros and cons from every corner. And in between holidays came, and then afterwards it was filed on 2nd of April. When already next day it was communicated by the government that we will go for the review. Then where is the government failure? I don't agree that government failure. And filing of review petition time is 30 days.
No, can
but
I
tell you,
add something
and
to it,
when
please?
the Supreme Court, when can strike down National Judicial Appointment Commission?
Okay, okay. No, before I go across to the politicians, I have to take
Can I get
this
20
question to
seconds to
Anand
add
Ranganathan.
something?
And Anand, you know one. Okay, Mr. Sapra, go ahead very quickly, please, though.
Yeah, very quickly, I just wanted to add, like Mr. Udit Raj was now talking, let me remind him that it was their own partner, LJP. LJP went in for a review petition within 3 days, like on 23rd they went in for a review petition. Now when LJP can go in for a review petition on the 3rd day, why government went on a review petition on the 11th or the 12th day? Secondly, now these riots, whatever has happened, are only in the BJP ruled state like Madhya Pradesh, Rajasthan or UP probably. Then you see Punjab, which is ruled by Congress. There was no riots, though Punjab has more scheduled
Sapra,
caste
I'll
representation.
come
They
to
have
the politics of this. I'm
22%,
sorry, I
whereas
will
these
have to
states
ask you to keep quiet.
16%.
No, Mr. Sapra, I will come to the politics of it later. I will discuss the politics of it later. I have to go across to
No,
Anand
I'm not
Ranganathan.
talking about
And
politics.
Anand,
I'm
the
talking,
crime
this is a
against
reality
SC/ST
also.
No, I will come to that later. I will come to the point that you're raising a little later on the show. I will go across to Anand Ranganathan now. And Anand, just to point out certain statistics from the National Crimes Record, it very categorically says that between 2009 to 2014, crimes against SC/ST went up. 40% against SC/ST, 118% against the STs. But the conviction rates have continued to be low, and in the period between 2007 to 2016, the average conviction rate in the SCs was 28.8, for STs it was 25.2, whereas the Indian Penal Code conviction rate is over 42%, 42.5%. How do you read these statistics? Because truth be told, the same statistics then also say that false cases that are filed under the SC/ST Prevention of Atrocities Act are just 9 to 10%. I don't somehow get the statistics then. I mean, is the Supreme Court then looking at just a very skewed set of statistics and delivering a verdict here?
Thanks very much for having me, first of all. Before I come to the issue at hand, which I believe is actually a matter of law as well as of politics, but let me straight away first of all answer the question that you asked, which is about the conviction rate. Now incidentally, today in Hindustan Times there's been an opinion piece published by Mr. Thorat saying that the conviction rate is actually only 1.4% of in 2016, which is actually wrong, because the Supreme Court itself has stated that the conviction rate is actually around 25%. And if you go by the NCRB data, the one that you've quoted, it's actually come down from 2009, which was around 30%, to about 25%. Incidentally, this was one of the reasons that were quoted in the Supreme Court judgment, saying that the reason why the conviction rate is so low is because of frivolous cases. This was their argument, by the way. But now let me, be that as it may, let me come to the larger issue, Supriya, and there are two of these, and let me just make very quick points on both. The way I see it largely is that in a democratic nation, there are two kinds of people, one who respect the judiciary and the other who think they are the judiciary. And what's going on, what we saw yesterday, was actually just an appalling demonstration of most of us thinking that we are the judiciary. I mean, I dare say, did people even read the judgment? I mean, I would actually say that what Mr. Goel, honorable judges, Mr. Goel and Mr. Lalit have done is no less brave than what one Justice Khanna did in the famous, or rather infamous, habeas corpus judgment in 1976. They have actually, and if you read their rebuttal today to the government's reply, it is that they're standing against arbitrary arrests. They are standing for civil liberty. And if one of the maxims in international law is something called the Blackstone ratio, which is that it is better that 10 guilty persons escape than that one innocent suffer. And for all the people who are actually talking about emancipation of SCs, NSTs, and how we must strive forward, and how this has been diluted. Incidentally, if you, I actually personally object to this word that is being used, that is the SC/ST Atrocities Act being diluted. If you stand up for civil liberties, you're not diluting it, you're actually enforcing it. And let me just quote the one and only Dr. B.R. Ambedkar. This is what he said, and I quote him verbatim: "Freedom from arrest without due process of law is the kind of liberty that is fundamental. Not only fundamental, it is also most essential. About its value, there can be no manner of doubt." So where are we heading? Where is the country heading when a decision by the Supreme Court leads to the killing of 9 innocent people, or 9 people who protesting on the streets? So that is where the law, the matter of the law is. Now, as if I can have another 20 seconds talk about the politics of it, because I think that's also very important, which is, in fact, I would like to mention what Mr. Bhadoria said about the recent atrocities. And in fact, you mentioned, if you can take some data out, you would actually see that from 2009 to 2013, when BJP was not in power, the crimes and atrocities, these are the reported atrocities, with astonishingly high charge sheet rate, by the way, and that is how NCRB qualifies it. Atrocities against Dalits increased by 17.3%. In 2012, just 1 year, 5 Dalits were raped every year. Mr. Bhadoria mentions a lot of atrocities against Dalits that are committed by Hindus. Absolutely, I completely condemn it, and I believe BJP has not done what it should have done to actually stem that. But he never ever mentions that in the last 1 year, Muslim mobs have actually committed more than 30 attacks against Dalits. Why does he not say that? Why are you being selective? The moment we are, and this is something that actually Dr. Ambedkar fought for, and we cannot say, none of us can say that,
Right. Okay, Anand Ranganathan, you made a very valid point there, and I think I'm going to get Mr. Bhadoria. Yes, Mr. Bhadoria, I'm coming to you for a reaction, but I'm also going to ask you this very simple question. In 2016, 5,347 cases were found to be false. In 2015, 11,024 cases were resulted in acquittal or discharge. Is the apex court here telling the society at large that the act has been grossly misused and even used for purposes other than protecting the SC/ST community?
Well, let me just quote the statement I have seen today itself in the social media, an interview given by Justice Balakrishnan, and he is a former Chief Justice of the Supreme Court, and he says that we don't have a single Dalit in the Supreme Court as judges. I mean, look at the empathy level. What I am trying to say is the issue which Udit Raj raised, and I wanted to supplement it then, and I want to reiterate now that unless those people who empathize with this cause, and in a country of 125, 130, 40 crores, 35 crores of Dalits, we talk of 100, 200, I mean, there is hardly a village where atrocities are not taking place. There's hardly a gully mohalla where atrocities are not taking place. And I can say it with full authority in my command, there's hardly a township, a village where the Nirbhaya Kand with the Dalits are not being committed. Now, what are we talking about? There's so much of, I don't think we even have we can't fathom the kind of pain and agony that they have to go through. So therefore, I think this debate may be very good, but let me say this, any dilution of the anti-atrocity of the Dalits Act would only further marginalize them. And as far as what our friend was saying, he's talking about minorities. The Sachar committee places the minorities even at a lower inferior status than the Dalits. They are also almost at par with the Dalits. The Sachar committee, which is a very valid document, a very cumbersome document, which also underlines how much exploitation and marginalization they are going through, and they are as if they are the ones who are the haves of this country. I mean, it is a very erroneous, wrong representation which we are trying to make of a community, which is not at all true.
I will just ask my guests to be a little brief because I've got just last 5 minutes left on the show. I request each one of you to be a little brief so that I can cover some ground. No, I will come to you, Mr. Udit Raj. Just wait for a minute. Satwik, I'll come to you, Mr. Verma. And Satwik Verma, the question really is that a lot of us are blaming, the violence that happened yesterday. But the violence did happen because the state failed to control law and order. I mean, that is one aspect that we all seem to be missing. The violence occurred because there was administrative failure. Why are we not talking about that? I mean, everybody is talking about Dalit Dangal. The reality is that violence happened because the state wasn't prepared to do its own part. Satwik Verma?
Supriya, I completely agree with you. I think that, the state law and order and the state machinery should have been prepared. I think that, this is not the first time the Supreme Court has passed what I would say, or what at best can be termed, if at all, certain uncomfortable decisions in the past as well. We saw some of this happening post the Padmavati judgment, and we heard the Supreme Court very clearly stating that it is going to uphold the freedom of speech and expression post that, and it is the responsibility of the state law and order and machinery to prevent crimes. I also agree with the other commentator, Mr. Ranganathan, that it would be grossly unfair to term this ruling completely as dilution. And if I may just steal 20 seconds, Supriya, to mention, it is not very common for review petitions to be heard in court. Review petitions normally are heard in chambers by circulation, point one. And it's important that we all understand that. Number two, it is also not very common that unless the court reconsiders a decision, it does not stay its order. Therefore, all of these expectations and demands that the Honorable Supreme Court should have stayed its order is a gross interpretation of how our Supreme Court functions and what the statutory rules are. And therefore, while at one level, the Supreme Court has realized the gravity of the situation, the Supreme Court has therefore asked all of the participants, from what I've read today on media channels, to submit their written submission. The Supreme Court has not expressed any views one way or another. because what it has done in its judgment of March 20th is only
Satvik,
to
I get your
uphold
point there.
the
I'm not
constitutional
getting into
scheme under
legalese of
Article
this.
21, which is the right to life and personal liberty. And that right cannot be deprived without due process.
Okay.
That's all.
Satvik, I'm sorry, I'll have to cut you short there. Okay, I have to cut you short there. Charan Singh Sapra, I'll come to you. I'm going to take quick closing comments from everybody. 2014, the BJP won 47 of the 66 reserve seats all across India, winning all 17 in Uttar Pradesh. Is this a fight to get that vote bank back? That's the big question. Are politicians all rallying around the cause of Dalits because no one can shun them away? And is this all eventually a fight for that vote bank? Mr. Sapra.
See what I am seeing in 2014, people voted, whether they are Dalit or whichever caste they are, people voted for Narendra Modi because he showed that he will give some different governance to this country. But now he has failed in last 4 years. The basic thing is that the RSS and the Bharatiya Janata Party, they want to end the reservation, but they don't want to end casteism, because this casteism is, garnering votes for them. So you see everywhere, whether a boy gets killed in Gujarat when he is riding a horse, whether it is Bhima Koregaon, where riot-like situation was there and cases were registered on the Dalits. 3,000 Dalits cases were registered, whereas the actual culprit Milind Ekbote was arrested after 2 months, and Shambhaji Bide, who is the main culprit, he is still out. And the Chief Minister of Maharashtra has given him a clean chit.
Okay.
See the way BJP is working, that they deliberately want to divide this country into casteism. They want upper caste versus
Mr.
the
Sapra,
lower caste.
I get your point
And
there.
that's
I will
how
have
they
to
could
cut you
win
short.
the
I've just got 2 minutes on the
2019
show.
election. That is
One
the strategy
second.
behind
Mr.
it.
Udit Raj.
Yeah.
Okay. Mr. Udit Raj, I will come to you, and please be brief because I will take one more
And
question
because
to
a
Anand Ranganathan and
gentleman
end this
spoke,
show.
I don't
My
remember
question
his
to
name.
you is that the BJP, one second sir, the BJP has a stubborn tag. People believe that you haven't stood up for the cause of Dalits, you've done this out of political fallout. What is the strategy for 2019 going to be to win them back?
See, don't link it to the politics. This is a different matter. And second thing is that Sabka Saath Sabka Vikas is our slogan, and we are doing in that direction. But the gentleman just spoke. He says that there is a gross misuse of this act. Why is not looking at 376, which is much more misused when other laws are much misused? And second thing, that by acquittal rate, you find it out that cases are frivolous. Maybe that from filing up FIR till adjudication, there are loose ends, and the government counsel and charge sheet and investigation or argument are not done. This is not the artistic to gauge that the is some misuse. Of course, I said it that of course in some cases there may be misuse of the cases, but why not the same take of the Supreme Court or that gentleman who spoke about the 376 and other acts?
Okay. Right. Anand Ranganathan, I'll come to you, and please be brief. I really request you. Did we remove or dilute acts like TADA or the UAPA, which were grossly misused? We didn't do that. Why are we, and I know you have an objection to the word dilute, but why are we reviewing this then? We haven't reviewed acts in the past.
So just very quick, just 2 points, and one of them would be a prediction. So just 10 seconds each. One is that, I couldn't hear what Mr. Bhadoria was saying clearly, but I am appalled by the insinuations that are going on in the media since yesterday, insinuating that because the two judges weren't Dalits, that is the result of, this judgment is a result of that. Now, I think that is absolutely condemnable, and I think it's probably might be a contempt of court as well. And the irony is that the same journalists who were actually condemning and saying that turning against the SC-ST Supreme Court judgment are actually today, because of the overturned fake news, so-called fake news act. They were saying that what if a journalist is accused wrongly of spreading fake news? So you can't have double standards when you're covering the basis of law as well as politics. And lastly, 5 seconds, I believe sadly this is going to go the Shah Bano way. I think come the monsoon session, the Parliament is going to overturn the Supreme Court judgment. Yeah. And it's a sad day.
All right. So what if the court does go ahead and this turns into a Shah Banu-like thing? But thank you very much for this wonderful panel, for being with me this evening. This is a very, very important subject that we must spend time, discuss, debate, deliberate. This is about how India is going to develop. This is how about every community needs to be represented. And of course, this is also about a lot of politics at stake. But on that note, we'll call it a wrap here on the India Development Debate. Up next is Top 10 at 10 with Tanya Bharadwaj.